So an H-1B work visa is the most common work visa we use in the United States immigration system. It's mostly for professionals, which means that it's a work visa for people that have earned at least a bachelor's degree or higher, or it's for an equivalent, and the job requires a bachelor's degree or higher. An H-1B duration is for 6 years total, counting all of the stints an employee has had at all of its employers in the United States. So an H-1B can be extended beyond those 6 years, though, in some limited circumstances. For example, an H-1B can be extended beyond the 6 years max if the employee files his PERM application, which is the first step in a green card process, by the end of year 5. It can also be extended if the employee's I-140, which is the second step in the green card process, is approved before the H-1B expires. So there's a little bit of a wrinkle when you're getting H-1Bs. H-1Bs are the most common work visa, so a lot of professionals look for an H-1B. They're foreign nationals in the United States. However, the United States government only issues a limited number of H-1Bs every year. You can apply for your initial first-time H-1B only one time a year. It's April 1st every year. It's 6 months before the start date, effective start date of your H-1B, which is October 1st every year. Approximately 3 times as many employees file for their H-1B every year than slots allowed. That means you only have somewhere about a 30 to 50% chance every year of getting an H-1B. If you don't get an H-1B, you should be talking to an immigration lawyer about some kind of creative solution to stay and work in the United States. Generally, an H-4 is for the dependents of an H-1B, which is the spouse and the children of an H-1B. Generally, an H-4 spouse cannot work. However, there are limited circumstances under new law that allows an H-4 spouse to be able to work. For example, an H-4 spouse can apply for work authorization if the H-1B spouse has an I-140 approved, which is the second step in the green card process. An H-4 spouse can also apply for work authorization if the H-1B spouse has filed a PERM application, which is the first step in the green card process, at least 1 year before the 6-year max of the H-1B expires. An H-1B, unlike many other work visa categories, has a wage requirement. You have to pay an H-1B employee at least the actual wage or the prevailing wage for that job in that geographic location. An actual wage is what other employees that are similarly employed are paid, and the prevailing wage is determined by a Department of Labor database that's online that you can look up that you search by job and geographic location. You have to pay the higher of the two at all times. So that also means if you're going to discipline an H-1B employee, you can't dock their pay if it's going to dip them below the prevailing wage. It means if you're going to change their job, you can't change it to a point that dips them below the prevailing wage. So an H-1B is an approval that you get for that employee by name at that geographic job location for that very specific job and those job duties. If any of those materially change, the job location changes, the job duties materially change, then you have to file an amended H-1B. It's not a difficult process, but it's just something you have to do to notify the USCIS that you have made that kind of substantial change, and they approve that the change still qualifies them for an H-1B. An H-1B and any other work visa category does not entitle that employee to any special employment contract or term of employment. They are at will, just like the rest of your employees probably are at will. They can be terminated at any time for any reason except for an unlawful bad reason. So you can terminate the employee, an H-1B employee, anytime. The difference is with H-1Bs, you have to do a couple of things. You have to notify the USCIS that you've terminated them with a letter. You have to offer that H-1B employee a return ticket to their last foreign residence abroad. Most people won't take it, but you have to offer it, and you should offer it in writing, at least an email if not in a letter, so that you can prove that you've met that legal requirement.